2013 Green Book, Section G, General Assurance Terms, Conditions for Participation in Federal State Programs. The Department of Education has developed a general assurance documents that must be signed all agency organizations to receive federal or state funds. This requires federal regulations 34, Title 34 Code Federal Regulations 76301, the Education Department General Administration Regulations (EDGAR), which receives general applications, sub-grants, and sub-recipients participation in federal grant programs funded by the U.S. Department of Education that meets the requirements of Section 442 of the General Education Provision (JEPA). Applicable federal statutes, applicable regulations of federal agencies, state law regulations pertaining to expenditures of state funds. The return to Florida Department of Education Bureau of Comptroller 914 Turlington Building, 325 West Gainey Street, Tallahassee, Florida 323990400. The community-based organization, faith-based organization, independent colleges, or other non-governmental agencies are required to submit a certification page of general assurance with original signature along with each other submitted to the department. Florida Department of Education General Assurance Terms and Conditions for Participation in Federal State Programs. Authority for data collection, Title 20 U.S. Standard Code 1232EA, planned use data. The requirements established by the United States Code and noted by the Title 20 Education, Chapter 31, Subchapter 3, Section 1232E stipulates that each local education agency which participates in an applicable program under the federal funds is made available to such agencies through a state agency shall submit to such an agency general application containing the assurances set forth in Section 1232EB. The participation covered the participation with the local education agency, all other organization participation, state, federal programs administered in Florida Department of Education. The assurances are set forth below the general assurances section. The general assurances will be in effect of the duration of the project. It covers the state agency and board administrates the project. Covers that the application shall not require the submission of amendment for such application unless required by the change in federal state law. Other significant changes of circumstances affecting the assurance in such application, the superintendent agency and other authorized officers must sign for a certification return to the following address. No payment for project awarded will be made by the agency without a current sign for general assurances from a form on a file. The further information, contact the Florida Department of Education Bureau of Comptroller 8 at area code 850-245-0401. Certification. I authorize under the undersigned, this authorized official of the named agency, organization, state of Florida, hereby for the participation in federal funded and state funded education programs on the behalf of the name of the agency below. I certify that the agencies will adhere and comply with the general assurances requirements outlined in the project application amendment procedures for federal state programs. The Green Book. Your title, type agency name, agency number, and type name, and title authorized official agency head. I certify the agency will adhere to the assurances contained within the set of general assurances terms and conditions of participation in federal state programs as applicable to the project which the agency is responsible. Signature must be original, date, and the area code and telephone number. Return original to Florida Department of Education Bureau of Comptroller 914 Turlington Building, 325 West Gainey Street, Tallahassee, Florida 323990400. The school district, states, colleges, state universities, governmental entities are required to have a signed certification page of general assurances on the file of the Department of the Borough's Comptroller bearing an original signature of the current superintendent of the school districts or current agency head, president of other agencies. Community-based organizations, faith-based organizations, independent colleges, or non-governmental entities are required to submit a certification page of general assurance with an original signature allowed. general assurance along with each application submitted to the department. General assurance is hereby given that the extent of the applicable, the recipient of the legal authority to apply the federal state funding and the instructional, managerial, and financial capability, including the sufficient pay to the non-federal share of the project costs as applicable to ensure proper planning, management, and completion of the project described in this application submitted. The recipients will administer each program covered by the application in accordance with the applicable law, regulations, applicable laws, regulations, statutes, rules, policy, procedures, and program requirements. The recipient will comply with the department's project application amendment and procedures of federal state programs called the Green Book. The control funds provided in the recipient under each of the program title property acquired with those funds will be in a public agency. Public agency will administrate those funds and property. The recipient shall establish a proper accounting system in accordance with generally accepted accounting standards. The recipient usually official control funding account of the procedures that will ensure the proper disembarkment of or accounting to the federal state paid of the agencies under each of the program. Access such records shall be made authorized representative U.S. government agencies, Florida Department of Education, Florida Department of Federal Financial Services. Audit general state of the Florida purpose of the program official auditing monitoring. The recipient will submit such reports to the Florida Department of Education to the U.S. Department of Education as required by the Florida Department of Education and the U.S. Department of Education to perform their duties. The recipient will maintain official problematic records, including those which official and pragmatic records, including those required in Title 20 U.S. Standard Code 1234F, provided by the access to those records necessary for those departments to perform their duties. The recipient will provide reasonable opportunities for systematic counseling within the participation of teachers, parents, interested agencies, organizations, individuals, including educational-related community groups, nonprofit organizations planning for operation of each program. Any application, evaluation, periodic plan, reporting relating to each of the program will be made readily available to the parents and other members of the general public. For the projects involving construction, project is not inconsistent with the Florida Department of Education overall plans for construction of school facilities. In developing plans for construction due to the consideration will give excellency architecture due to the compliance with the standard prescribed by the Secretary of Education under the Section 794 of the Title 28 in order to ensure the facilities constructed over the use of the federal funds are accessible to use and by individuals with disabilities. When required federal program legislation, all construction contracts awarded by the recipient, subrecipients in the excess of $2,000 shall include a provision of compliance with the Davis-Bacon Act, Title 40 U.S. Standard Code 276A, intent sequence, and supplemented by the Department of Labor Regulations, Title 29 Code Federal Regulations, Part 5, Labor Standards provisions applicable to contracts covering federal finance and assisted construction. The recipient has adopted effective procedures acquiring, disseminating teachers and administrative participation in each group, such significant information from educational research, demonstrations, similar projects for adopting and use where appropriate, promising educational practices developed through such project. Such procedures shall ensure compliance with the applicable federal law requirements. The recipient will not expend funds under the applicable program to acquire equipment, including other computer software, in an instance in which the acquisition results in a direct financial benefit to any organization representing the interest of the purchase entity and its employees and affiliate of such an organization. The recipient establishes safeguards to prohibit employees from using their position for a purpose of constituting or presenting appearance of personal organizational conflict of interest of personal gain. The recipient will initiate, complete, and with applicable time frame after the receipt approval of the award agency. The recipient will comply with the federal state laws relating to non-discriminating. This includes not limited to Title VI, Civil Rights Act of 1964, Public Law 88 through 352, which prohibits discrimination based on race, color, national origin, Title 9 of the Education Amendments of 1972 is amended by the Title 20 U.S. Standard Code 1681, 62, 1683, and 1685, and 62, 1686, which prohibits discrimination on the basis of sex. Section 504 of the Rehabilitation Act is amended by Title 29 U.S. Standard Code 794, which prohibits discrimination based on handicaps. The Age of Discrimination Act of 1975 is amended by Title 42 U.S. Standard Code 6101, 6107, prohibits discrimination on the basis of age. The recipient will comply with the Public Law 93 through 348 regarding the protection of a human subject involved in the research development related activities supported by the award of assistance. Recipients will comply with the requirements of Gun-Free Schools Act of 1994. The recipients will cause to be performed and required financial compliance audits according to Signal Audit Amendments 1996 of Office Management Budget Circular A133. Audits of state, local governments, and nonprofit organizations. Section 21597 Florida Statutes. Florida Single Audit Act is applicable. The recipient ensures no federal appropriate funds have been paid, will be paid, or on behalf of recipient on the behalf of the recipient to any person for attempting to influence an officer or employee of any agency, a member of Congress, or an officer of an employee of Congress, or an employee or member of Congress in connection with making a federal grant, the entering of any cooperative agreement, an extension, continuation, renewal, amendment, modification of any federal grant or cooperative agreement. Recipient will comply with the requirements of Title 34 Code Federal Regulation Part 85, government-wide debarment and suspension, no procurement. The recipient certifies that neither it nor officers presently debarred or suspended proposed for the department declared ineligible or voluntarily excluded from or covered transactions by federal department agencies. Recipient certifies that it will maintain a drug-free workplace, will comply with the requirements of the Drug-Free Workplace Act of 1988. The recipient will comply with all applicable requirements of all federal, state laws, executive regulations, policies, in each group program funded. If applicable, the recipient will conduct assessments and consist with Section 1111B3 of No Child Left Behind Act. If applicable, recipients will annually assess students will have been in the United States for their 3 or more consecutive recipient annual assets of the English proficiency of participation limited English proficiency children consistent with Section 1111B7 and No Child Left Behind Act. If applicable, after timely and meaningful consolation, the receipt will be provided opportunity for the children enrolled in private, non-private schools and educational purposes of such equitable participation activity services provided by federal funds, and will notify other official private schools of said opportunity. Educational services and other benefits provided, including materials, equipment, shall be secular, not neutral, or non-ideological. Expenditures for such other benefits should be consistent with the number of children to be served to expenditures of the program of the children enrolled in the public school or local educational agency. The failure to comply with general assurances and any aspect of the project application amendment procedures for federal state law in the Green Book may result in more restrictive conditions of project termination. Terms: application. A school district or any entity is seeking a project award of the Florida Department of Education. The project application of the financial budget. The application financial plan and the terms of the account and the amount showing the use of the carrying out of the showing the use of the funds carrying out the project objectives, services, activities found in the budget narrative forms DOD, the Department of Education 101. So activities are funded by a budget narrative formed with the DOE 101. On the budget documents required by the Florida Department of Education, budget period. The interval time in which the project period is divided into budgetary purposes. Capital outlay. Equipment, fixtures, and other tangible personal property of non-consumable, non-expendable nature, the value of the cost of which is $1,000 or more, and normal expected life of which is 1 year or more. Section 216.001, 273.02 Florida statutes. Disbursement, payment and made in cash by check or Viva other electronic means. Data universal numbers, DUNS, 9-digit issued Dun Bradstreet Company. By Duns and Bradstreet Company. This company provides business information for credit marketing and purchasing decisions. The Government Office of the Office of Management and Budget has adopted the use of the Duns number to keep track of how the federal grant money is awarded and disbursed. The equipment, a material item or non-expendable nature such as a built-in facility, a movable fixed and furniture, furnishing, and instrumental apparatus, a machine including the attachments, instructional, skill training device, or set small articles who are receptacles, repairable, those retaining this identity utility over a period of time in which the characteristics for the item of the class is a useful life of more than 1 year. Monitoring actions, activities, practices used in the Florida Department of Education to determine the funds are used in programs that are operated in accordance with the applicable federal and state statutes, rules, and regulations. More restrictive conditions, special requirements of restrictions imposed on a project recipient as a condition of the project approval for the Florida Department of Education. Obligations, the amount of orders replaced on the contracts awarded, service received, and or for a similar transaction during a stipulated project period, which require payments during the same or for future period. Private nonprofit organizations, an agency, organization, or institute not under the federal or public service supervision or control, which is owned by one or more corporations, association whose net earnings do not benefit, cannot lawfully benefit any private shareholder or entity. Private for not-for-profit organization, agency, organization, institute not under federal or public supervision control, which is owned by one or more individuals, partnership, corporation, association, to net earnings due or can benefit in any private shareholder or entity. Project, the service activities in the program of the entity agrees to provide a specified period of time using the state federal funds awarded to the project recipient. The project application, an entity request for the project awarded under the state and federal education programs administered by the Florida Department of Education. Project awarded. The approval of the project application is stated by the project awarded. Notification sent in the project recipients that specifies the amount of the fund awarded, the project period of any special requirements, restrictions to be imposed by the Florida Department of Education. Project period. The length of time for which the project has been authorized or awarded. Project recipient. The school district, local educational agency, public agency, including the faith-based organizations, the FBOs, and the community-based organizations, CBOs. Non-public agency has been awarded a project to provide services and activities described in the project application approved by the Florida Department of Education. Roll forward, unobligated balances of an award project that are allowed to be continued in subsequent funding periods. Supplies, all personal property excluding equipment, intangible property, debt, insurances, items of expendable nature that are consumed, worn out, deteriorated, and in the use of the loss of their identity through the fabrication and incorporation into a different or more complex unit or substance. Explanation of grants and management requirements. The following section elaborates on certain requirements, including legislation regulations referred to as the General Assurance section. This section explains the broad requirements that apply to the federal program funds. The accounts and records. The recipient shall maintain all accounts, records, and other supporting documentation pertaining to all costs incurred, revenues, other applicable credits acquired under each of the approved project for a minimum of 5 years. See Section C. Official program, all accountable, recorded retention for additional information, allowable costs, and account for the expending of project grant funds, and a recipient and subrecipient may only charge expenditures to the project awarded if they are in the payment of obligations incurred during the approved project period, B, in conformance with the approved project, C, compliance with all applicable statutes and regulatory provisions, D, the cost of allocable to the partial cost objective. E, spent only for reasonable necessary costs of the program. F, not used for general expenses required to carry out other responsibilities of recipients and subrecipients. Amendments. Unless otherwise stated, all project recipients should use the project amendment requirements and procedures described in the project application amendment procedures for the federal, state, and programs administered in the Florida Department of Education Green Book Section B's project amendments. Audit. The part of the applicable if the recipient of the state and local government of nonprofit organizations is defined in the Office of Management Budget Circular A-133 as revised in the event of the recipient expends over $500,000 or more federal awards in the fiscal year. The recipient must have a single program-specific audit conducted in accordance with the provisions of an Office of Management Circular A-133 as revised in determining the federal awards expended in the fiscal year. A recipient should consider all the sources of federal awarded, including federal resources received from the department. Determination amounts of the federal awards expended should be in accordance with the guidance established by the Office of Management Budget Circular A-133. An audit receipt conducted by the Auditor General in accordance with the provisions of Office Management Budget Circular A-133 is revised and will meet the requirements of this part. In connection with the audited requirements, the receipt shall also fulfill the requirements related to the auditee responsibility as provided in subchapter. Right in subpart C of the Office Management Budget Circular A-133 as revised. The recipient expends less than $500,000 in federal awards its fiscal year as an audit conducted in accordance with the provision of the Office Management Budget Circular A-133 as revised is not required in the event of the receipt expends less than $500,000 in federal awards in its fiscal year elects to have an audit conducted in accordance with the provisions of the Office Management Budget Circular A-133 as revised. The cost of the audit must be paid by the non-federal resources. The cost such of an audit must be paid by from receipt resources obtained from the non-federal entities. Audited state-funded programs. The parts of the applicable project recipient is not state entity as defined in Section 215.97.2 of the Florida State Statutes. In the event of the project recipient expends the total amount of the state financial assistance equal to in excess of $500,000 in any fiscal year, the receipt must have a single prospective project-specific audit if such fiscal year is in accordance with Section 215.97 Florida State Statute, applicable rules of the Department of Financial Services, Chapter 1055, 550 local government entities, or 10650 nonprofit or for-profit organization rules of Auditor General. In the determination of the state financial assistance expended in the fiscal year, the receipt shall consider all sources of the state financial, including state financial assistance received from the department, other state agencies, other non-state entities. State financial assistance does not include federal directed or pass-through awards or resources received by any non-state entity or for federal program matching requirements. 2. In connection with the audited requirements above, the project recipient shall ensure that the audit complies with the requirements of Section 215.97 of the 8 Florida statutes. This includes submission of the financial reporting packages defined by Section 215.97.2, the Florida State Statutes, Chapter 1050, 550 local government entities, 10650 nonprofit for-profit organization rules of Auditor General. If the receipt recipient expends less than $500,000 in state financial assistance in its official year, an audit conducted in accordance with the provision of Section 215.97 Florida State Statute is not required. In the event of the recipient expends less than $500,000 in state financial assistance, his official year elects to have an audit conducted in accordance with the provisions of Section 215.97 Florida State Statute. The cost of the audit must be paid from the non-state entities' resources and i.e. the cost such as audited must be paid from the project recipient resources obtained from the non-state entities. Pursuant to Section 215.97.8, the Florida State Statutes agency may conduct and arrange an audit for audits of state financial assistance that are in addition with the audits conducted in accordance with Section 215.97 of the Florida State Statutes. In such event, the statewide or state awarding agencies must arrange for the funding of the full cost of such additional audits. Reports to be submitted. Copies of reporting packages for audit conducted in accordance with the Office Management Budget Circular A-133 as revised shall be submitted with the required Office Management Budget Circular A-133 Subpart C blank 320D as revised by or on behalf of the recipient directly to each of the following. The Florida Department of Education Bureau of Contracts, Grants, and Procurement Management Services, 344 Turlington Building, 325 West Gaining Street, Tallahassee, Florida, 323990400. The Florida Department of Education Program Office of Address stated on the project award notification. The Federal Audit Clearinghouse designated on the Office Management Budget Circular A133. The number of the copies required for the section blank 320D should be submitted for the Federal Audit Clearinghouse at the following address. The Federal Audit Clearinghouse Bureau, the Consensus 12010 East 10th Street, Jefferson, Illinois 47132. Other federal agencies pass through the ETNIs in accordance with the Office Management Budget Circular 133 Subpart C, Section blank of 320 A and F. The copies of financial reporting packages should be submitted on behalf of the recipient directly to each of the following: Florida Department of Education Bureau of Contracts and Grants, Procurement and Management Services, 344 Turlington Boulevard, Sterlington Building, 325 West Janney Street, Tallahassee, Florida, 323990400. Florida Department of Education Program Offices that address stated on the project awarded notification. The Auditor General is the 401 Pepper Building, 111 West Madison Street, Tallahassee, Florida, 323991450. Copies of reports of management letters shall be submitted on the behalf of the recipient directly to the Florida Department of Education Bureau of the Contract Grants and Procurement Management System, 344 Turlington Building, 325 West Gaining Street, Tallahassee, Florida, 323990400. Florida Department of Education Programs Office of the address stated on the project awarded notification. Any reports, management letters, or other information required to be submitted on the department pursuant to this agreement shall be submitted timely in accordance with the Office Management Budget Circular A133 Florida State Statutes, Chapter 10550 local government entities, 10650 nonprofit or for-profit organization rules of auditor in general as applicable. Recipients who submit the financial reporting package of the department audit completed in accordance with the Office Management Budget Circular A133, Chapters 10550 or 10550 local government entities, 10650 nonprofit or for-profit organizations. Rules of audit in general shall indicate that the date of the reporting package shall deliver the recipient in accordance accompanying the report package. The Davis-Bacon Act, as amended in Title 40 U.S. Standard Code 276, the 10th sequence, when required with federal program legislation, all construction contracts as awarded by the recipient subrecipients more than $2,000 shall include a provision in compliance with the Davis-Bacon Act, the Act 400 U.S. Standard, Title 40 U.S. Standard Code 276, the 10th sequence, supplemented by the Department of Labor, DOL, Regulations, Title 29, Code Federal Regulation, Part 5, Labor Standard Provision, applicable contracts covering federal finance, assisted construction. Under this act, the contractor shall be required to pay the wages of the laborers or mechanics are at the rate are not less than minimum wages specified in wage determination made by the Secretary of Labor. In addition, contractors shall be required to pay the wages not less than 1 week. The recipient shall place a copy of the current prevailing wage determination issued by the Department of Labor in each solicitation, and the award of the contract shall be continued upon the acceptance of the wage determination. The receipt shall report all suspected reported violations in federal awarding agencies, Department of Labor regulations, rules, and instructions concerning amendment of the Davis-Bacon Act. Other labor laws can be found in Title 429 Code Federal Regulations, Part 1, 3, 5, 6, and 7. De-embarment and suspension of other responsibility matters as required by Executive Orders 125549, 126889, Department suspension and implemented at Title 34 Code Federal Regulations, Part 85. The progressive recipients of the primary covered of the transaction defined in Title 34, Part 85, Section 85, 105, 85, 110, 85, 200. No contract shall be made and no parties identified by General Service Administration, excluding parties list system as excluded by the federal procurement, non-procurement programs in accordance with the Executive Orders 12549 and 12689. Department suspension. This list contains a number of parties debarred and suspended or otherwise excluded by agencies and contractors declared ineligible under statutory regulatory authority other than the Executive Order 12509. Contractors with award that exceed the small purchase threshold shall provide the required certification regarding their exclusion status that they are principal employees. The federal government employs the requirement in order to protect the public interest and to ensure the other responsible organization individual do business with the government entities or with a do business where the government receives the spending government grant funds. Failure to adhere to these requirements may have serious consequences. For example, disallowance of cost, termination, project debarment to and ensure this requirement is met. There are four opportunities to obtain satisfaction that sub guarantees contractors are not suspended, debarred, and disqualified. They are: the application certifies that it is principal they are not presently debarred, suspended, proposed, or debarred, and declared ineligible, voluntary, excluded for covered transactions by any federal department or agency. Have not within 3 year period preceding the application have not been convicted or have a civil judgment rendering against them for the commission of fraud or criminal offense in the connection with obtaining, attempting to obtain, or performing a public or federal, state, local, or transaction or contract under a public transaction, violation of a federal, state antitrust statutes, commission of an embezzlement, theft, forgery, bribery, falsification, destruction of records, and making false statements, receiving stolen property. Are not presently indicated for otherwise criminally, civilly charged for the government and any federal, state, local, and for the commission of any of the offenses enumerated in this certification. Have not within 3 year period preceding this application had one or more public transactions, federal, state, or local, terminated for the cause of default. Whether the application is unable to certify any of the statements, this certification he or she attempts the explanation of this application. Drug-free workplace grantees other than individual. As required by the Drug-Free Workplace in 1988, the implemented Title 34 Code of Regulations 84-200 and 84-610, the applicant certifies that they will continue to provide a drug-free workplace. The publishing of a statement notifying the employees that the unlawful manufacturing, distribution, dispensing, possession, or use of controlled substances is prohibited in the grantee's work, and specifying this action will be taken against the employees for the violation of such a prohibition. And the establishing is required in Title 34 Code of Regulations, Part 215, ongoing drug-free workplace awareness program to inform the employees about the dangers of drug use in the workplace. The dangers of drug abuse in workplace. The grantee's policy of maintaining a drug-free workplace and available drug counseling, rehabilitation, employee assistance, and programs. The penalties that may be imposed upon employees for drug abuse of violations occurring in this workplace, requiring that each employee engaged in the performance of the project may be given a copy of the statement notifying the employee in the statement that a condition of employment under the project of the employment will abide by this term of statement. Notify the employer in the writing of his or her conviction for the violation of the criminal drug statute occurring in the workplace not later than 5 calendar days after such a conviction. Notifying the agency is written within 10 calendar days after receiving notice of an employee conviction of violation of criminal drug statute in the workplace is required by Title 34 Code of Regulations 84-205 CE for an employee otherwise receiving actual notice of employee's conviction. Employers convicted employees must provide notice of including position to the Director of Grants and Contract Services, U.S. Department of Education, 400 Maryland Avenue Southwest, room 31204, GSA Regional Office Building, number 3, Washington, D.C. 202-024571. Notice shall include the identification numbers of such affected agents or such affected grant. Taking one of the following actions as stated by the Title 34 Code of Regulations 84-225B and Title 34 Code of Regulations 84-2255B with 30 calendar days receiving required notice of the respect to an employee who is convicted of a violation of a criminal drug statute in the workplace. taking appropriate personal action against such employee upon to including the termination consistent with the requirements of the Rehabilitation Act of 1973 as amended by requiring such an employee to participate in satisfactory in a drug abuse assistance rehabilitation program approved by such purposes of federal, state law, local health, and law enforcement, other appropriate agencies. Make a good effort to maintain the drug-free workplace through the implementation of the requirements stated above. The DUNS number, the Data Universal Numbering System. The federal government requires the organization to provide a DUNS number as part of their grant application proposal. The Office of Management and Budget has adopted the use of DUNS numbers to keep track of the federal grant money is awarded and dispersed. The DUNS number is a 9-digit issued Dun Bradstreet Company. This company provides business information for credit, marketing, and purchasing decisions. Some entities will also have known as the DUNS plus 4, which is used to identify specific units with a larger entity. Register for the DUNS numbers with free charge of non-obligation to purchase any product of Duns Bradstreet. Any authorizing official organization should request for the number. Generally, it takes a day to obtain DUNS number by phone 186. An authorizing official or organization should request the number. Generally, it takes 1 day to obtain a DUNS number by phone 1-866-705-5711, while applications through the Duns Bradstreet website can take up to 30 days. All recipients and subrecipients funded the federal funds must obtain a DUNS number prior to the period of the project awarded. General Education Provisions Act Requirements Section 427 Federal Requirement Equity for students, teachers, and other program beneficiaries. The purpose of Section 427 of the General Education Provision Act is to ensure the equal access to education to promote the educational excellence, ensuring equal opportunities to participate for all eligible students, teachers, and other program beneficiaries, and propose projects to promote their ability for such students, teachers, beneficiaries to meet higher standards. Further, when designing their abilities, the grant applications must be addressed in special needs equity Special needs equity concerns for the mighty effect that the ability of the students, teachers, other program beneficiaries to participate fully in proposed project. Program staff with granting institution must ensure that the information required in Section 427 of the General Education Provision Act is included in each application of the Department of Funds. There may be a few cases such as research grants in Section 427 may not be applicable because the projects do not have individual project beneficiaries. Contact the government printing office staff should be believed a situation of the kind exists. In addition, all application packages of discretionary grants and cooperative agreements must include a notice to all applicants attached that explains the requirements of Section 427. The statute highlights 6 types of barriers that can be impeded to equal ability, access, or participation: gender, race, national origin, color, disability, age. Based on local circumstances, the applicant can be determined whether these or other barriers may prevent participation. For the access participation in federal assisted projects, how the applicant would oversee the barriers. These descriptions may be provided in a single narrative, and if appropriate, may be described in a connection with other related topics in the application. Application should be asked to state in the table of contents whether this is where this requirement is met. The Department of the Program and staff members are responsible for screening each of the application to ensure that the requirements of the section are met before making an award. If the condition is not met after the application has been selected by the funding of the program staff, and should contact the application to find while this information is missing. Documentation must be project file indicating the review was completed before the award was made. See the Education Department General Administration Regulations, EDGAR, Title 34, Code Federal Regulation 75-3231. The federal requirements relating to the grant selection criteria and oversight of accord. If any oversight occurred, the program staff may be given an application and other opportunities to satisfy his requirement. Must receive the missing information before making the award. All application of new awards must satisfy the provision to receive the funding. Those seeking the continuing awards do not need to submit information beyond the description, including in their behalf of the original applications of gun possession. as required by Title 14, Part F, Section 14601, Gun-Free Schools Act of 1994 for improving the American Schools Act. The application certifies the compliance with Section 10613A for statutes and student who is determined to have brought a firearm, any student is determined to have brought a firearm as defined in 18 U.S. Standard Code 921 to school, any school function, or any other school-sponsored transportation will be expelled with or without continuing education services from the student regular school for the period no less than 1 full year, referred to the criminal justice and juvenile justice system. School boards may be assigned to the students in disciplinary programs, second chance schools for the purpose of continuing educational services during the period of the expulsion. Superintendents may consider the 1 year expulsion requirements on the case by basis request that the school board not modify the requirement is determined to be in the best interest of the student in school system. Indirect costs and administrative fees. The Department has been given an authority to the U.S. Department of Education to negotiate indirect costs of the proposal to approve indirect cost rates for the school district. School districts are required to develop an indirect cost proposal. If they fail to do so, they will not be allowed to recover any of the indirect costs. The amount from the zero to the maximum negotiated rate may be approval from the program's project. The Department comptroller indirect costs shall only apply for the federal projects. State agencies, universities, state colleges. The department will allow other state agencies, including state universities, state colleges, to charge an indirect administrative or an overhead up to 5% of or the agency's rate approved for the appropriate consignant agency, whichever is lower. The rate may be charged on the total direct cost, disbursed less of the amount of subcontracts in excess of $25,000, items of equipment alterations, renovations, flow-through funds passed through or to another entity on the projects issued by the department. The rate is intended to be all-inclusive of the typical administrative overhead costs, including but not limited to the rental of office space, bookkeeping, accounting services, utilities, and alternate the department, which will approve the indirect cost rate of the 5% plus the direct charges of the typical administrative and overhead costs, such as office space rental, when such costs can be directly appropriated allocated to the program. Other agencies to be allowed to recover indirect costs as agencies other than the school district must furnish to the Department of Education comptroller a copy of the current negotiated indirect cost plan and has been approved by the appropriate cognate agency. Amount for the zero of the maximum negotiated rate may be approved for the program. The project department comptroller indirect costs shall be only applied to the federal projects. Restriction of funds of administration. Restriction on the amount of the percentage that can be charged in the project administration, which includes the indirect costs, will be reflected in the request for proposal, request for application, and or approve the project awarded notification or amendment where applicable. Administrative fees are for non-federal funds. An administrative fee may be approved for the department of the non-federal projects not exceeding the 5% of the total cost of the project. Interest income based on Section 216 and 181 and 16b the Florida State Statute 34 Code Federal Regulations 8021I. Project grant recipients shall promptly at least quarterly remit all interest earned on the cash advanced by the department. Lobbying. In accordance with Section 216, 3047 Florida State Statute, the disbursement of the grant, aids, and reimbursement of the lobbying is prohibited. Grants, aids, and appropriations for lobbying is prohibited. The department may not authorize or make any disbursement of the grants, aid, or appropriations pursuant to the contract grant to any of the person or organization unless the terms of the grant or contract prohibit the expenditures of funds for the purpose of lobbying of the legislature, the judicial branch, or the state agency. The provision of this section is supplemental to provision section 11.062 Florida State Statutes, any other law prohibiting the use of state funds for lobbying purposes, as required by Section 1352, Title 31 of the U.S. Standard Code, implemented by the N3-4 Code Federal Regulation Part 82, for the purpose of entering into a grant cooperative agreement under over $100,000 as defined in 34 Code Federal Regulations 82-105 and 82-110. The applicant certifies that No federal appropriated funds have been paid and will be paid on the behalf of undersigned to any person or for attempting to influence an officer, employee of an agency, a member of Congress, an officer, employee of the Congress, an employee of the member of the Congress in connection with any of with making any federal grants, entering into any cooperative agreement and extensions, continuations, renewal, amendment, modifications of any federal grant or cooperative agreement. If in any funds that are federal appropriated funds have been paid, we will be paid to any person. The influencing attempt to influence an officer, employee of the agency, a member of the Congress, any officer, employee of Congress, and employee of the member of the Congress in connection with the federal grant of the cooperative agreement under shall complete the submitted standard form, the LLL disclosure form of the reporting elaborating in accordance with its instructions. The undersigned shall require that the language of the certification shall include in the award documents of sub-awards of all carriers, including subcontracts, subgrants, contracts under the grants, cooperative agreements, and that of all sub-recipients shall certify and disclose them accordingly. Monitoring. In addition to the reviews of the audit to be conducted in accordance with the Office Management Budget Circular A133 section of 215.97 Florida State Statute, monitoring procedures may include but not limited to on-site visits as department staff, limited to school scope, audits defined by the Office Management Budget Circular A133 as revised, and other procedures by entering into the agreement with the project grant recipient agrees to comply with the cooperative with any of the monitoring procedures processes deemed appropriate for the department. In the event that the department determines the limited scope audit of the recipient is appropriate for the recipient agrees to comply with the additional instructions provided by the Department of Staff to the recipient regarding such an audit. The recipient further agrees to comply with the cooperative with any action reviews, investigations, audit deemed necessary for the Chief Financial Officer's Auditor General. More restrictive conditions. Project recipients found to be non-compliant with the fund sources requirements determined to be high risk shall be subject to imposition. More restrictive conditions. See Section G. Conditions of the approval, project application, project amendments, and termination of the project for additional information. Obligations for project recipients. Obligations will be considered to have been incurred by the project recipient on the basis of the documentary evidence of binding commitments of the acquisition of goods of property as is for the performance of work except for the fund for the personal services. For services performed by the public utilities for travel for the rental of facilities shall be considered to have been obligated at the time such services were rented, such travels were performed, and when the facilities are used. Ownerships of project intellectual property. The ownership of a project resulting from a project, ownership of products resulting from a project which are subject to intellectual property rights shall remain in the department unless they are such ownership explicitly waived in the following terms and conditions apply to all grants to projected recipients unless explicitly waived. With respect to all products created by the grantee for this project, the said materials will be property of the department. To the extent that any of the product constitutes work within the means of the U.S. copyright laws, the Title 17 U.S. Standard Code S 101 intent sequence shall be work for hire. In the event that the court or competent jurisdiction determines that the product material is not a work for hire, a matter of law, the contract shall assign to convey to the department all right, title, interest in the product or material, require its employees and subcontractors to do the same. The grantee agrees that the employers will not assert any ownership of the product produced under the project. The grantee should be responsible for requiring necessary releases or establishing appropriate contract provisions in its dealings with the employees' subcontractors in order to secure the department's rights. Any claim of the grantee ownership of the pre-existing copyright should be explicitly stated in the project documentation. The grantee agrees that if it hires any third party to perform any work of the project, and the work shall be work on for hire basis, shall not in any way infringe upon the department's ownership of the product. If the grantee agrees not to convey any of the rights in the product to the third party, if the grantee hires a third party to perform any of the work that involves the use of pre-existing intellectual content used by the third party should expressly assert in its ownership content and shall grant the grantee the department a non-exclusive license to use the product. The license agreement for the other agreement regarding the use of intellectual intellectual property developed under project that must be developed between the department and grantee in order to further the use of products in an educational committee. The participation of private school students and staff in federal grants. School and staff of non-public schools shall be given an opportunity for equitable participation in activity services conducted by the school district using federal grants. Appropriate personnel must be aware of the consult program specific guidelines discussed in the applicable program, statute, regulations, and guidances. Documents personal costs and time and distribution. Changes of the federal project for personal costs when treated as direct or indirect costs will be paid on based on payrolls documented in accordance with the general accepted practices of a local educational agency approved by the responsible official of the local educational agency as required by the Office Management Circular 87, when employees of the work solely for the single federal award of the cost objections charged and the salaries, wages must be supported personal activity. The reports PARs, which are periodically certification at least semi-annual for the employees work solely on the program for the periods covered for the certification. Those certifications must be signed by the employee supervisor over official having first-hand knowledge of the work performed by the employee. When the employees work on the multiple activities, cost objectives, each more the federal project, non-federal project, any indirect cost activity of the direct cost activity, the two or more indirect activities which are allocated using the different allocation bases on unallowable activity, the direct or indirect cost activity, the distribution of their salary, wages will be supported by personal activity reports, equivalent documents that meet the following standards, reflect on and after the fact distribution, actual activity of each employer, actual the total account activity which each employee is compensated, prepared at least monthly and most most coincide with one or more pay periods, signed by the employee. The U.S. Department of Education has approved in the Florida substitute system for allocation of salaries for federal projects. As part of the substitute system, the personal activity reporting system PARS may be implemented by the school district so long as they implemented in accordance with the department's approved substituted system. The documentation is available upon the request of the department of the Bureau of the Contracts, the grants, procurement of the management system. When the school district you choose to submit substitute systems, no variations are allowed within the specifications written authorization department. School districts choosing not to use the approved substituted system must implement in the system that meets all of the Office of Management Budget Circular ACE 87. School districts choosing to use the department substitute system must furnish the Department of Education Comptroller's Office district policies, procedures which specify the reporting months as well as actual time reporting instrument for the approval for each of the district. Given authorization to adopt the substitute system, written approval agreement will be in the effect of the duration of the district participation in the substitute system until such a requirement is changed for the department. Note, this does not authorize school districts to consolidate administrative funds except for as otherwise stated in the project awarded notifications or term of use as a basis for allocating personal costs. These methods may apply to only the department. Project effective dates. The federal program funds shall be obligated no earlier than the date of the project application was received by the department, determined to be substantially approved for the form of effective date of the federal grant, and which is later. For the state programs funded shall be obligated no earlier than the effective date of the legislative appropriation, usually July 1st. All project awarding notification reflection of the beginning and end dates of the project period of the dates of submission, final expenditures report. All conditions stated in the award notifications are considered binding on the project recipient. Project property purchases and a whole part of the federal funds should be used in the purpose of those federal programs accounted for in accordance with the applicable federal, state, and statute rules and regulations as follows. Disposition of equipment based on Title 34 Code of Federal Regulations 8032 of the Section 273.025 Florida State Statute Rules and 691I 72.002 Florida Administrative Codes. When original replacement equipment acquired by under the grantee, subgrantee is no longer needed for the original project of the program or other activities generally previously supported by the federal agency, disposition of the equipment will be made as follows. Item of the equipment with the acquisition cost less than $1,000 may be retained and sold or otherwise disposed with no further obligation to the awarding agency. Incoming received from these sales will not be reported to the department. Items of equipment that with acquisition costs in excess of $1,000, a useful life of 1 year or more, must be retained as sold. An awarding agency shall have the right to the amount of the calculated multiplying the current market value preceded the sale by awarding the agency's share of the equipment. In case when the grantee sub-grantee fails to take appropriate disposition action, the award may direct the grantee sub-grantee to take excess disposition action. The Department of the policy concerning the proceeds received the sale of the property, which in current per unit fair approximate the value of over $1,000. The net amount of the receipt from such sales will remain in the sub-grantee level to be used in the same ongoing program funds for such sales will be treated as other program income in the same ongoing programs. The type of the income should be amended into the current years of the project which in the sales occurred. It should be reported on line 11 of the project disbursement report in the form DOE 309409. D399, 499, and 599 is the total of the official year in the states acquired. The identification incomes necessary to meet the report of the requirements of the U.S. Department of Education, completing the documentation of the type of the income. Expenditures shall be made for the monitoring, auditing purposes. Income from the sale of the type of the property shall be recorded in the agency's special revenue accounting as the other income identified as such as federal cash advance reconciliation at the end of each of the first official year. If the agency is no longer receiving funds for the particular project of the program, this includes such as the equipment sales will be returned to the Florida Department of Education. Equipment sales will be returned to the Department of Education to be forwarded to the U.S. Department of Education. Upon termination of the project, as is the discretion of the department, all equipment property purchased from the project funds will be transferred to the location specified by the department, and all necessary actions to transfer the ownership of the records of equipment and property to the department or to designate will be taken. Disposition of real property. Disposition of real property will be handled on the individual basis of the accordance of Title 34 Code Federal Regulations 8031. Local educational agency will consolidate coordinated real property disposition program coordinator responsible for the particular project of the program. For the real property was purchased entirely, will the state fund shall meet the minimum requirements of the Auditor General as defined in the county district. Will tangible personal property publication additional local procedures. See Section 5 for the program. Income, interest income, and disposition equipment for the additional information. Projected prayer in the public elementary and secondary schools as required in Section 9524 the Elementary and Secondary Education ESEA of 1965 as amended by the No Child Left Behind of the 2001. The school district and other local educational agencies must certify annually that they have no policy that prevents otherwise denies participation in constitutionally protected prayer in the public elementary and secondary school. Purchasing receipt may use their own procurement policy provided that they may meet the minimum requirements of federal, state, and statutes, rules, and regulations. Reporting requirements, financial disbursement. Federal awarded project recipients on the cash advances required to report the disbursement using the cash advance report disbursement system. By substituting project summary disbursement per part in the DOE 3099, 499, 599 annual for each of the activity. The reports must be received by the DOE Comptroller's Office by the 20th of the month, succeeding the final month in which the disbursements were made. The failure to submit these reports in a timely manner may result in an increase of delay in monthly cash advance losses of funds, and federal project recipients are required to report in accordance with the instructions stated with the project award and notification. State project recipients shall be submitted reports as required with the department. Audit reports shall be sent in accordance with Section 21597 of the Florida State Statutes. Florida Department of Education Bureau, the contractor contracts, grants, procurement, management services, 344 Turlington Building, 325 West Gainey Street, Tallahassee, Florida, 323990400. Retention and access to records required. Related to the retention and access to the project grant records is determined by the federal, state laws, regulation, federal grant regulation 34, Code Federal Regulation 8042 specifies the following related to retention and access requirements for the records. A1 applies to all financial programmatic records, supporting documentation, statistical records, or other records of the grantee, sub-grantees, which are required to be maintained by the terms of this part of the program regulations of the grant, otherwise responsibly considered as pertinent to the program regulations of the grant. In Florida, general records is scheduled the GS1 state and local for the state and local government agencies available for the DLIS. Department of State, Florida, USA, BARM, Genu, uh, General record schedule includes the following requirements related to the grant files: record series documentation, activities relating to the grant-funded projects conducted by the grant recipients, including the application and projects of the recipient expenditures of the grant. These files may include, but not limited to, the grant applications, contracts, agreements, grant status narratives, financial reports, supportive documentation. Project completion has not occurred. Project completion has not occurred until all reporting requirements are satisfied and final payments have been received. The length of retention of these records of Florida is 5 years after completion of the project, provided by the applicable audits have been released. Single audit. A single audit act. If a recipient expends state financial assistance equal to in excess of $500,000 in an official year, the recipient should subject the requirements of Florida Single Audit Act. See resources. If the recipient expends federal financial assistance equal to in excess of $500,000 in official years, the recipient is subject to the requirements of Federal Single Audit Act. Projects and grants awarded by the Florida Department of Education to the subrecipient is subject to audits and monitoring by the Department, supplemental and non-supplemental, in accordance with the project specifying, authorizing the laws, regulations, and implementations of those laws federally funded for the generally be used to the increase to the extent of the particular level of non-federal funds with that would be available to the absence of federal funds in no case to replace these non-federal funds. The Stevens Amendment, the federal and funded projects must be complied with the Stevens Amendment of the Department of the Defense Appropriation Act, found in Section 8136. Which provides with issuing statements, press releases, requests for the proposal, bid solicitation, other documentation, subscribed projects, programs funded in whole and part of the federal money, and all grant receiving federal funds, including but not limited to state and local government, in which shall clearly state 1% of the total cost of the program or the project will be financed with federal money. 2, the dollar amount of the federal funds of the project or the program. 3, the percentage of the dollar amount of the total cost of the project or the program will be funded by the non-governmental services. Travel. All travel performed in connection with the approved project activities must be in compliance with the current Section 112.061 Florida State Statutes, which covers and per diem allowances, travel expenses, and the Florida Department of Education Travel Manual is available at Florida Department of Education or Comptroller Forms ASAP. Section 112.064.114 Florida State Statutes applicable to counties, county officers, district schools, boards, special districts, metropolitan planning organizations establishing statutory authority, allowing specified entities to establish travel reimbursement rates, other established in Section 12.061 6A, 6B, and 7D Florida State Statutes. Each entity must comply with, in accordance with the statute, include the project application, a comply application data of the EG ordinance, resolution, policy, rules, and detailed description of the project budget form. Section 8, complaint procedures.